Welcome you to attend the CTQP Exam Technique Workshop Online Part 1. And today lectures, we first of all look at some examination skill for the subject of corporate censorship and compliance. That is, the name is CSC. And for the coming recording lectures, okay, before we start, a look at some past exam paper, Excel report, and the subject answer. I would like to give you some ideas and overview of the whole syllabus and share with you some ideas how to prepare for the examination and what are the major focus for the examination. Just because before we prepare and study any material, you should know what is the expectation from the examiner. Just because during the 3-hour examination, you are expected to demonstrate your knowledge, how to fulfill the subject learning outcome. So that's the reason why, first of all, let's take a look on the learning outcome. And because of the learning outcome requirements, so that there are 4 recording lectures, and every recording lectures will cover one section for our syllabus. Let's say for the first recordings, we will take a look on part A of our syllabus, which cover the topic of the directors, company secretary, effective board practice, and member, etc. Okay, so that's the reason why in the next recordings, we will focus on section B of the syllabus. Okay, and then in the first recording, focus on section C and section D, and finally, at the final recording lectures, we will focus on section E of our syllabus. Okay, so that for the 5 learning outcomes, this can also demonstrate every section requirements, okay, including that for the first learning outcome, okay, company secretary and the government professional, and also the directors, management, shareholders, and other stakeholders. Okay, so that in section A of the CSC syllabus, we will focus on looking at the corporate secretarial practice and compliance issues for the directors, members, and company secretaries under the company audience and the listing rule. Okay, so that you should know and have a good knowledge regarding the role and function of the directors and officer of the company, as well as the concept of shareholders and the corporate secretarial practice on shareholder protection. And the second learning outcome focus on section B of our syllabus. Okay, this means during examination, you should demonstrate the principle of regulatory requirements and the best practice, and how to apply them to ensure compliance. Okay, so that when compared with learning outcome 1, that is section A of the syllabus. Section B focus on the company compliance issue under the company audience, the listing rule, and any other law and regulation. Okay, and for the first learning outcome, this focus on section C of the syllabus, including the expectation and compliance with regulatory requirements regarding company meeting, which include shareholder meeting and the board meetings. Okay, so that in this topic, we will go through the relevant listing rule and the company audience requirements for these 2 types of company meetings. And as a government professional, you should know how to organize an effective and lawful meetings in order to pass the resolution. The fourth learning outcome focus on share and share capital. Again, looking at the company audience and the listing rule. Okay, how to raise up the capital, how to reorganize and restructure the share capital of the company, how to reduce the share capital, and some capital exercise, let's say share option scheme, okay, or scrip dividend scheme, are the proper exercise for more of the private company and listed company. So that as a company secretary, you should know all the law and regulation regarding the share capital of the company. And the final learning outcome focus on section E of the syllabus, which the topic include the listing rule and the SFO requirements on the listed company. And in the final learning outcome, as a company secretary, how to provide the advice regarding the major main board listing rule requirements, including Chapter 13, Chapter 14, and Chapter 14A of the listing rule, just because the relevant chapters is related to continuing obligation of the listed company, notifiable transaction, and collected transaction. Okay, so that for the first recording lectures, we focus on learning outcome 1. Okay, and we will make use of the section A of the syllabus to go through some exam checklists and what are the major focus for section A. According to Hong Kong CGIs, the total studying hour is recommended to be set at 200 hours. Okay, so that depends on the mark allocation for each of the section. Okay, let's say for today recording lectures, when you look at section A, the institute expect you to spend around 40 hours in this topic, okay, which is 20% of the whole syllabus. Okay, so that in today's recording lectures, we will focus on share with you some tips how to prepare section A during these 40 hours. Okay, when you review the whole syllabus as a company secretary, you should know a little bit ideas on the Hong Kong law and regulations. Okay, so that's the reason why before we study CSC, I recommend you to study Hong Kong company law first. At least you should armed with the relevant legal knowledge. And after you know all the legal requirements for the company and directors and these officers, then in this subject, we will focus on the strategy and the procedures, how to ensure compliance, including the respective company secretarial practice, which include how to prepare the board minutes, how to obtain board approval, how to convene the shareholder meeting, how to pass the resolution at the meetings, okay, how to file the statutory return with the regulatory bodies within the deadline. Okay, so that every procedures and the step are required to comply with the legal requirements. Okay, so that for the whole syllabus, there are 5 major law and regulations which are important for the examination. In particular, the company ordinance, that is the CO, okay, as well as the listing rule, that is the LR. Okay, and depends on the topic. Okay, for example, for some topic including company winding up, please look at CWUO, okay, regarding member and creditor voluntary winding up and compulsory winding up. Okay, regarding the topic of the inside information disclosure, please look at the SFO. Regarding the concept of mandatory general office, please refer to takeover code requirements. Okay, because of the takeover code, just in case of the increase in shareholdings by the controlling shareholders, please understand under what circumstances the increase in shareholdings will trigger the takeover code requirements. Okay, so that the controlling shareholder should act as the overall, okay, to provide all the shareholders the offer price, and then the shareholders has the option to dispose the shares to this controlling shareholder at the offer price. Okay, we will take a look on mandatory general offer issue in section B. Okay, because there are many Hong Kong law and regulation, please be careful to read the question carefully, including how to identify the type of company, okay, as per the question requirements. Okay, one good example is that for the first sentence of the long question, the question may indicate the type of company. Let's say the company is a private company, limited by shares or limited by guarantee. Okay, in other words, what kind of Hong Kong law which are applicable for this type of company? Okay, needed to say this should be CO and CWUO in case the question cover winding up. Okay, so please do not provide any answers which relate to listing rule, SFO, and takeover code just because the question requires that the company is a private company and only the company ordinance chapter 622 governing the compliance issue of the private company. On the contrary, with the type of company is a listed company, okay, that is listed in the Hong Kong Stock Exchange. And the company may be a Hong Kong incorporated company or, let's say, Cayman Island company. Whenever the company is a listed company, please mainly apply listing rule for that question. Just in case the listed company is a Cayman Island company, please focus on Part 16 of the company ordinance because the Cayman Island listed company is a non-Hong Kong company which has a place of business in Hong Kong, so that Part 16 of the CO is applicable. In case the place of incorporation in Hong Kong, you need to say we need to also apply the CO requirement for that question. Okay, and in case the question cover inside information, as I mentioned before, please also look at the implication of the SFO. In case the question cover mandatory general offers, please focus on takeover code requirements, which is applicable to the public company and listed company in Hong Kong. Okay, just because if you misread the question and quote the wrong law and regulation, you will fail in the examination. So that please identify the type of company and apply the respective law and regulation. And sometimes the question requirement may also provide you some information on that. Okay, so that when the company asks you about company ordinance for the private company, please do not mention any listing rule, for example. Okay, I would like to share with you the passing way of the CGQP examination. Some students mentioned that the passing rate was very low. The HKCGI examination was very difficult. Okay, of course, apart from studying in a good heart, please also have a good exam strategies. Okay, in particular, how to present the answer to the question in order to fulfill the passing requirements. When you review the passing rate of the CXC, honestly speaking, for the earlier examination under the CGQP exam series, the passing rate was only 25 to 30%, which the passing rate was quite low. Normally, the passing rate was below 30%. But in 2023, I'm happy that student performance has a significant improvement just because after reading the relevant past exam paper and exam report, then they understand the focus of the examination so that they have a very good exam strategy to produce the answer during examination. So that when you review 223 passing rate, okay, we understand that the passing rate was 40%. So I hope that in coming examination in 224 and 225, I hope the passing rate was also 40%. Okay, so that your passing opportunity will be higher than before. Okay, but of course, all of these are only statistics and for your reference only. Please look at yourself. In case you have a very good preparation of the examination and you own a very good examination strategy in CSC, I hope that your passing rate should be more than 90%. Okay, when you prepare for the examination, not only CSC, okay, what is your sources of material? Okay, of course, the more important piece of material, of course, is the past exam papers and also this marking scheme and also examiner report. Okay, just because you will understand what is the main focus for the exam papers. Okay, so that you can rely on the past exam paper to review the study pad issued by the HKCGI. Apart from that, the subject of the CSC is very practical, assuming that you are working at a private company and listed company. Okay, so that you should apply your knowledge in CSC in a practical manner. As a result, I also recommend you, apart from study pad or any written material, please also read the website from the regulatory bodies. One good example is CR, Company Registry. That is the domain name is cr.gov.hk, which the website provide a very update and useful information for you to study CSC. Apart from that, you should also take a look on the website of the Hong Kong Stock Exchange, including HKEX New, just because both the company announcement and circular are published for the purpose of complying with the listing rule. When you're reading the company example on this announcement and circular, you can also earn some knowledge regarding the compliance issue for the listed company under the listing rule and the SFO with applicable. Okay, so that please take a look on some practical example for this subject, just because CSC itself is very practical for the company secretary and governance professional. Okay, in this PowerPoint, I highlight some summaries from the previous exam report, including why students fail in the examination and why student has a very good and excellent performance. Okay, needed to say, study hard is very important and the exam strategy is also important. Application is also important just because in section B, most of the questions are scenario type question. Okay, you are expected to produce the answers, which is linked up with the theory and practical situation, and then provide the analysis of the question and give recommendation to the directors in order to ensure compliance. Okay, so that some proper examples are expected to be coded, which link up with your answers on the question. Okay, so that you should have a sound knowledge in the whole syllabus. And during the examination, please also apply all the knowledge in a practical manner. Okay, so that's the reason why when you review the comment for distinctions, you need to say, the student performance, the answer standard and qualities is far more than the marking scheme requirements. Just because marking scheme is only a standard answers and help the marker to give the mark to the candidates. However, if you are able to provide more application skill and your legal principle can directly link up with the practical situation and then provide a very good recommendation, evaluation, judgment, and your answer can be supported by the comprehensive example, then your mark should be excellent on the condition that your answer is fulfilling the question requirement and assuming that you read the question carefully and directly code the theory and application for the answers. Okay, so that please bear in mind that HKCGI examination is very practical. In order to obtain distinction, your application skill is very important as a professional company secretary. Okay, they are the summaries. Why previously the examiner has a comment on lower grade student. Okay, including that student may not have a good preparation. They have a little knowledge on the whole syllabus, or some students they heavily rely on the past exam paper and subjected answers, which may not be relevant to the question requirements, or the student only that memorize everything without analysis on the question. And of course, reading the question is very important. So in the today lectures, I would like to make use of some past exam papers to guide you how to read the examination question and understand the focus of the examiners. Just because if you misread the question and then provide the irrelevant answers, you will fail in the examination. Please do not copy and paste the so-called model answers, which may not be relevant to the question requirements. Okay, and also this syllabus is very practical, so I strongly recommend you to look at some law-related readings. As I mentioned before, that is the CR website and Stock Exchange website, okay, to enrich your knowledge in the syllabus. Okay, during the 3-hour examination, your presentation of answer is very important to help you to pass the examination. Okay, I would like to give you some tips regarding how to give answer to the question. Okay, first of all, form size should be normal. One space between the paragraph is very important. And your written language should be professional. Your reporting should be professional as a company secretary. And it is also important to apply headline and sub-headline. After reading the question, you should understand the focus on the question and then please apply the focus as a headline and sub-headline to give the presentation of the answers. Okay, so that because of the headline reason, you are expected to provide both the point form and paragraph form answer in section B. Just because section B is a long question, you are expected to produce a report in the long question. But of course, in section A, just because there are 5 short questions, point form is sufficient enough. Please make sure that you have provide 5 points for that 5-point answers. Okay, and in order to fasten to give the answer, please use abbreviation, something like about the professional jargons, CO, SFO, CG code, AGM, AML, ESG, INED, etc. And finally, application of the question is very important instead of the fact presentation. Again, please do not that memorize everything from our syllabus. Just because you are expected to use your own language to apply the legal principle in a practical manner. After reading the question, you should understand the main focus of the question. And then please focus on the focus as a headline and subheadline. And then give the answers in both the point form and paragraph form, okay, including the analysis, application, recommendation, and conclusion to the scenario. Please do not copy and paste the model answers. And when you answer question B, please also look at the mark allocation. Let's say in section A 5 mark, if you are around half pages to 1 pages and maximum of 9 minutes. But I prefer that you should spend less than 9 minutes for section A short question, just because section A means you know or you don't know. You can get 5 mark or 0 mark. Okay, so that please do not spend so much time on section A, just because section A focus on the basic legal principle on the whole syllabus. On the contrary, in section B long question, basically every question may have question A and question B. Okay, please look at the mark allocation. This may be 10 mark and 15 mark respectively. So that 10 mark, you should write 1 pages at least to 1.5 pages, spend around 80 minutes. For 15 mark question, please use around 1.5 pages to 2 pages. And the time is expected to be 27 hours. And please make sure that a good time management is very important in the examiner. Please do not overrun the examination time. Otherwise, you should have sufficient time for other long questions. Okay, so that please prepare your words for time counting and allow you to have some time to read the question carefully. And during examination, please also consider if you are able to close the section numbers of the listing rule, the company audience, and CG code, the extra mark may be given, but it is not a mandatory requirement. Okay, we understand that according to the syllabus, there are many section numbers which this is very difficult to memorize and code them during examination. This is only highly recommendation, just because this may provide a very good impression for the examiner. Just because examiner know that, okay, this candidate know the answer, just because he or she is able to close the relevant section numbers. Okay, one good example is, let's say, according to CG code C.2.1, okay, which is one of the famous CG code. The role of chairman and chief executive should be separate and should not be performed by the same individuals. Okay, please bear in mind that if you are able to code C.2.1, that should be bonus mark. Even though you fail to code C.2.1, but you must demonstrate your knowledge in the role of chairman and chief executive, which should be separate, so that these 2 positions should not be performed by the same individuals. Then you can still obtain a full mark if you are able to code the relevant legal principle. C.2.1 can leave a good impression for the examiner only, but the more important is that you must code the correct legal principle, okay, and regulation, okay, under the respective law and regulation. Okay, and finally, please try to make use of the previous CGQP as well as IQS past exam papers. Okay, and I recommend you to look at all the CGQP exam papers, including Excel report and subject answer. And also IQS exam, that is corporate secretariatships. between 2005 to 2009, even with IQ exam was quite old. But because the syllabus was very similar with the CGQP syllabus, so that some of the past exam paper in IQS exam has a very good reference value. Or some of the CGQP exam question may be copied from the previous IQS exam papers. Okay, but please make sure that you should update just because in the recent years there has many amendments on the listing rule and the company order, so that you should let yourself update in case you apply the previous material. Not only IQ exam, this also includes CGQP examination, just because the latest past exam should be November 2023, but do you know that after 2023, that is starting from 2024, there has been several amendments on the listing rule. Okay, so that we need to update the marking scheme just because some of the regulatory requirement has been changed because of the amendment of the listing rule. So please try to update yourself for all the law and listing rule update. Okay, and finally, when you present the answers, excluding section A just because you should apply point form. Let's say for section B, mark award is not based on point taking, which is based on overall assessment of your answer. So that's the reason why your application and analysis and using the relevant headline to illustrate the focus of the examination is very important to let you pass in the examination. No need to worry about that. I missed 1 or 2 points just because the assessment is based on the overall assessment. And more importantly, your application skill for the question is very important as per the learning outcome requirements. Okay, so that's the reason why section A and section B are total different questions, because section A focus on factual question, while section B focus on scenario-based question. Okay, and more of the question focus on, according to the statistic, more than 40% is related to CO, more than 45% is related to listing rule, and a little bit SFO and takeover code. Of course, just in case the question asks you about winding up, please also apply CWUO. Okay, so that's the reason why in order to quick understanding for the whole syllabus, I strongly recommend you to look at the past exam papers, including CGQP and IQS past exam papers. Okay, now I would like to give you some focus on section A just because for the first recording lectures, we will focus on learning outcome 1, that is company secretary, directors, and members. Okay, now I would like to highlight, let's say in topic 1, there has been some past exam paper in CGQP ask you about company secretary. Okay, let's say I highlight some of the headings which was previously the past exam question. Okay, one good example is for the role of company secretary. There has been past exam in 2022 November, question 6, ask you about the qualification of the company secretary, appointment, resignation, or that is vocation of office of the company secretary. Okay, later on we will focus on that. And regarding topic 2 of the syllabus, that is the directors, I also highlight some previous past exam paper asking the student the concept of shadow director and alternate directors and also research directors. Okay, you should know all of them. And interestingly, you can see alternate director and research director were quite popular in the previous past exam papers. Another question on June 2023 asks you about director qualification. And more of the question also ask you about the appointment of the new directors. Okay, some other questions regarding director, including director induction, director duty, director disqualification, retirement by rotation, as well as removal of directors. Okay, so that's very interesting. When you're talking about, when you read topic 2, that is the directors, I recommend you, first of all, look at the respective topic first. If possible, apart from study past and past exam paper, you can also refer to the official website. For example, at the Google, you can type the word something like about the director duty, then the the internet search will display all the results regarding director duties. You can take a look on that. Again, the topic of the CSC is very practical for the candidate. Please do not memorize everything from the syllabus. Okay, regarding topic 3, under the section 8 of the syllabus, there are some topics which include board evaluation, board committee term of reference, that is ACRC and nomination committee, and also the model requirements. Okay, so that they are also the major focus, okay, for the examination. Okay, now we have a little bit focus on different topic under the topic of the director, company secretary, and effective board practice. Okay, now I would like to highlight some of the key points for the whole syllabus, okay, regarding the topic of the company secretary, director, and effective board practice. Including that, first of all, you must know the qualification of the company secretary under the company ordinance and the listing rule. Okay, for example, under section 474 of the CO, every company shall have a company secretary. Otherwise, without company secretary, that is unlawful under the CO. And the role and function of the company secretary is to fulfill statutory duty under the Hong Kong law, including filing the statutory return, maintaining statutory record, including register and minute book. The company secretary is responsible for organizing the board meeting and shareholder meetings. The company secretary is responsible to ensure that the company can operate under the compliance requirements for the CO. Okay, so that the duties of the company secretary is to perform statutory duties. This means that with the company secretary is negligent, mistake, omission, or careless, that is unlawful just because the company secretary failed to discharge his or her statutory duty. Okay, so that this position is very important. Okay, however, how about the qualification of the company secretary? Okay, according to the CEO, that's very simple for the individual, ordinary resident in Hong Kong, or body corporate, which this register office or place of business should be in Hong Kong. Okay, that is corporate company secretary. Okay, which is allowed for the private company. Okay, the function of using corporate company secretary, needed to say, is to limit the liability of the company secretary, as I mentioned before. In case of the negligence by the company secretary, the company secretary may be personally liable on that, so that the corporate secretary may enjoy limited liabilities because of the body corporate reason. How about who are disqualified as a company secretary under the CO? Okay, one good example is auditor, and this employee cannot act as the company secretary. And secondly, if the company has a sole director only, then the sole director cannot act as a company secretary unless the company has a two directors and any one of them is a company secretary. This means that one director cannot act at a dual capacity as a director and company secretary at the same time. Okay, one good example is that when execute the documents and the common seal is required, and just in case the seal should be affected under the signature of one director and one company secretary, then the same individual cannot act for these two positions at the same time. That is to sign the two signature. One is for director and one is for company secretary. Okay, just because the law restrict the dual capacity in this situation. Now, look at the listing rule. What is the professional qualification? The requirement is far different from the private company just because there are 3 types of professional qualification which are recognized by the Hong Kong Stock Exchange. One is HKCGI member. The second is solicitor or barristers. And the first one is CPA. Okay, so that's the reason why only the Hong Kong respective professional qualification, they are qualified as a company secretary. And not only the professional qualification, the stock exchange will also consider the relevant experience of the company secretary, including the length of employment, familiarity with the CO, LR, SFO, CWUO, and the takeover code, which are exactly the CSC secrets. Okay, and I hope that after you pass the examination, you can also satisfy the relevant experience according to the listing rule requirements. And 15 hours, okay, in each financial years to receive professional training. That is the minimum requirements. And the stock exchange also accept any other professional qualification in other jurisdictions so that the company may apply with the stock exchange, okay, regarding these requirements. Okay, and according to the HK Stock Exchange, okay, regarding the waiver application for the qualification of the company secretary, the stock exchange on 222 August has issued the guidance letter and provide some factors under what circumstances the stock exchange may grant the waiver so that the disqualified person can act as a company secretary. Okay, for example, where is the principal business activity? It is outside Hong Kong, which the answer is yes. The stock exchange may most likely grant the waiver. Okay, just because the main operation is located outside Hong Kong, so that the company secretary may not have the Hong Kong professional qualification. Okay, and also the listed company was able to demonstrate the need to appoint a person who does not have the qualification nor relevant experience. And the board meetings, the board should also consider the individual who are suitable to act as a company secretary. Okay, and for the waiver, the proposed company secretary must be assisted by the qualified person who has the respective professional qualification so that when you see the listed company appoint a joint company secretary, one of them should be proposed company secretary who are not any one of these professional, as well as another company secretary who has the relevant professional qualification. And in case the listed company breach the listing rule, the waiver can be revoked. Okay, so that some conditions are required is that during the waiver period, the qualified person should assist the listed company to comply with all the Hong Kong law and regulation. And also during the waiver period, this allows sufficient and reasonable time to enable the proposed company secretary to acquire the relevant experience according to the listing rule requirements. Okay, and according to the guidance letter from the stock exchange, the waiver period will not be more than 3 years. Okay, so that after 3 years, the proposed company secretary should show that he or she had acquired the relevant professional qualification and or academic background. Okay, and also the company should demonstrate the measure and system which facilitate the proposed company secretary to discharge the duties, and also show that the listed company has a very good internal control system to ensure legal compliance. Okay, so that after the end of the waiver period, the stock exchange will not automatically deem the proposed company secretary to be a qualified secretary. The company must demonstrate and obtain confirmation from the stock exchange that the proposed company secretary has attained the relevant experience and discharged the function of the company secretary. Okay, so that the following factor will be considered by the stock exchange, including the compliance history as well as the relevant training of the proposed company secretary. Okay, apart from that, previous exam question also asks you about the resignation of the company secretary. And not only resignation, this may also include removal of company secretary or the death of the company secretary. And for the resignation, the company secretary is required to serve a notice of resignation and then give the letters and notice to the register office of the company in hard copy or in electronic form. Okay, just in case there is no notice of resignation, then the board may consider another alternative, that is removal of the directors. Okay, however, for the removal of director, this should be passed as an ordinary resolution at the general meeting, just because only the shareholders can pass the ordinary resolution to remove the directors. And a special notice is also required by the members, okay, for the removal of the company, for the removal of the directors. Okay, so about that, this should be removal of the directors, which requires shareholder approval. For the company secretary removal, the board, that is using simple majorities, can remove the company secretary. Okay, and after the resignation or removal, update the register of company secretary and file the form ND2A and notify all the bankers. Okay, and they are the procedures for the training of the company secretary, okay, including using the board meeting, file the form ND2A and update the register of company secretary. And for the listed company, apart from the above mentioned procedures, the listed company should publish the announcement regarding the training of the company secretary at the website of the stock exchange and the listed company, and to file the contact detail form with the stock exchange. And please also submit the certificate confirming the professional qualification of a company secretary. Okay, for example, the HKCGI or HKICPA membership certificate. Okay, so that if you are working at the listed company, you must familiar with this form. Okay, FF004 regarding the contact detail for directors, supervisor, authorized representative, company secretary, and compliance officer. Okay, and regarding the training of the company secretary announcement, please also include below information. Okay, you can refer to the HKEX News for the training of company secretary of a listed company, so that at the disclosure, please provide confirmations whether there is disagreement with the director from the resided company secretary. And at the announcement, please disclose any matters in relation to the resignation that need to be brought to the attention to the shareholders and the stock exchange. Okay, so that you should develop a good habit, okay, to review and study the listed company announcement. Okay, so that they are the listing rule requirements for disclosure. Okay, now look at the directors. As I mentioned before, some short questions are about what is shadow directors, alternate director, and research directors. Okay, so that shadow director under the company law means he or she has not been formally appointed by the board of directors. Shadow director may not participate in management of the company. However, the shadow director may give instruction, okay, to the appointed director and employee, which they should act according to the shadow director instruction. Okay, so that's the reason why, even though, let's say, the largest and major shareholders, which is not a directors, with the major shareholders can provide instruction to the directors and employee, and they are required to act, okay, under this instruction, then the major shareholder may also deem that as a shadow directors for all purposes. Okay, so that's the reason why one good example is professional advisors. Sometimes professional advisors are invited to attend the director meetings. When provide any advice, please do not give any instruction to the board of directors how to act. Professional advisor must restrict their advice to their area of expertise, for example, the accountant or property transaction. With the professional advisor can provide a wide range of professional advice, they are likely to be a shadow directors. Okay, apart from that, you should know who is alternate directors. Again, there is no authorities, okay, under the CEO to appoint the alternate directors. However, the article may permit the directors to appoint the alternate directors, who is a person appointed by the current directors to act on behalf in their absence. And then, unlike shadow directors, appointment of alternate director is subject to formal appointments, okay, including that board approval is required. Form ND2A should be filed with the CR. register of directors should be updated. Alternate director also bear the same responsibility as our directors. In practice, alternate directors are appointed for specific board meetings so that if the director is unable to attend, so that the alternate director can attend the board meeting and give the voting instruction during the meetings. What is research director? Please refer to section 455 of the CO. This means that the law allows if the company has only one member and only sole directors, and they are the same person, then the research director can be appointed just in case the sole director has that. Okay, the advantages for this CO is to avoid any deadlock for the company in case of director death. Okay, so that if the director is dead, then the reserve directors will deem to be the director of the company and continue to operate the company. Okay, so that the nomination of the person as a research director may be ceased, including resignation of research director. The shareholder as a general meeting revoke the nomination. The director in respect of whom the person was nominated ceased to be the sole member and sole director of the company for any reason. Okay, including that the company has two directors, for example. Okay, so that the nomination of the research director should be terminated. And you should know the qualification of the directors. In particular, according to the CO, the director must attain the age of 18. And I also list out some ground for disqualification, okay, including unsound mind, bankruptcy, removal of directors, or because of the restriction from the law to act as our company directors. Okay, and also the court may also award the disqualification orders to disqualify someone. He or she cannot act as our company directors. Okay, so that before the appointment of the new directors, we can conduct the CR search, okay, for just disqualification orders, whether the proposed candidate is disqualified by the court. Okay, you can conduct the public search for those disqualification orders. And not only the law, the model article also provides the ground for director disqualification. Okay, including that the article may prevent someone to become a director of the company. Okay, again, you can also see that model article disqualification is similar to the CO requirements on just disqualification. Okay, regarding the chain of director, you should know the procedure for the private company, including the board approval, file the Form ND2A with the CR, and also update the register of directors. Okay, and more importantly, in case for resignation, with the resigned director believe that the company has not filed the Form ND2A, then the resigned director can file the Form ND4 in order to discharge his duty as a director. Okay, so that you should know the rationale for using ND4. Okay, why the resigned director filed the form with the CR. Okay, just because the director may resign at any time. Okay, unless otherwise provided by the articles. Okay, so that with the resigned director indicate on Form ND4 whether the notice of resignation has been delivered to the company or not. Okay, Form ND4 will have no effect unless just notice has been delivered. Okay, according to the article requirements. Okay, unlike company secretary, as I mentioned before, there is no shareholder approval requirements for the removal of the company secretary. However, for the removal of directors, there is a shareholder approval requirement and special notice is required. Okay, so that the shareholders should give the special notice at least 28 days before the relevant meetings. And then the director should convene a board meeting to authorize the convening of a general meetings and then dispatch the notice of the general meeting. For AGM, at least 21 key a day. For any other general meeting, at least 14 key a day. At the general meeting, the shareholder pass the ordinary resolution, which is more than 50% of the voting share of the company. And then after passing the auditing resolution, the company should file the Form ND2A with the CR within 50 days and update the register of directors. Okay, so that this is more complicated for the company to remove these directors. Okay, now look at retirement by rotation reappointment. That is another popular question in the examination. Apart from the resignation and removal of directors, another way to ask the director to quit from the board, that is retirement by rotation and reappointment. Again, please refer to the company article requirements. Okay, just because CEO is absent on this point. Model article of a private company is also absent on this point. Only the model articles of a public company has a director rotation and reappointment requirements. And of course, for the public company, the shareholder can also amend the Bexel resolution to include the requirement of the director rotation and reappointment at the AGM, okay, by using Bexel resolution to amend the company article association. Okay, so that according to the model article of a public company, first of all, for the new appointment of director, which is appointed by the board, then at the first general meeting, then the director should retire and then subject to re-election. And every director should be subject to retirement by rotation at least one every 3 years. Okay, let's say AGM is a good example, okay, for the director rotation and reappointments. And then the AGM, if the number of director is not 3 or a multiple of 3, then the number nearest 1/3 must retire from office and be eligible for re-election at the AGM. Okay, and apart from that, the director to retire shall be those who has been longest in office since their last election. Okay, so that you should know some procedures for the change of director for a listed company. Okay, unlike private company, before the board approval, the company should hold the nomination committee and the remuneration committee, including consider and recommend to the board suitable candidate for appointments. And remuneration committee is to approve the director remuneration. And after obtaining the recommendation from these two board committees, then the board meeting can be convened and pass the board resolution for the appointments. Okay, so that I also list out the checklist from the Hong Kong Stock Exchange regarding the requirements for the appointment of new directors. Okay, we can see that Form FF004, that is the contact details of the newly appointed director, is important. And also, in case of any change of the contact detail of the existing director, please also use this form to update the new contact with the stock exchange within 28 days. This also includes any director who has been resided for 3 years. In case of any change of the contact detail for the resided directors within 3 years, the company is still required to update the stock exchange. And more importantly, when you read the past exam paper, there is no just requirement just because of the amendment of the listing rule with effect from 2023 December of 31. Okay, previously, the newly appointed director is required to execute Form B, that is director undertaking. Because of the amendment of the listing rule, director undertaking has been included at the listing rule requirement. So that for the new appointment, the director must obtain legal advice from a firm of solicitors regarding the requirement of the listing rule and the director duties, and the possible consequences to make a false declaration or give false information to the stock exchange. Okay, so that the company should ensure that the proposed director has obtained the legal advice before new appointments, and also disclose in the next public annual report following the director appointment, including the date which the director has obtained the legal advice, and each proposed director has confirmed his or her understood his obligation as a director. So that this PowerPoint is totally new for you just because they are the new listing rule requirement. You cannot find this in the past exam paper or even study pad. Okay, so that the listed company is required to publish the announcement and the content of the announcement, including the following detail. You should know all of them. And of course, you can study some pattern example of the listed company, okay, regarding the announcement on the training of directors. If the director has a security interest, please also disclose the interest in the shares within the meaning of the Part XV of the SFO, director remuneration. For resignation, please also disclose the reason for the director resignation, including any information relating to disagreement with the board and a statement as to whether or not there are matters that need to be brought to the attention of the security holders. Okay, so that if the director has any security interest, please bear in mind to report DI form to the stock exchange. Okay, and for the INED appointments, INED should also sign the independency confirmation and also submit the contact detail form with the stock exchange. Okay, and finally update the register of directors. And also file and upload the list of director and their role and function, so that apart from the company announcement, the list of director and their role and function should also be public at the website of the stock exchange and the company. And this is the example after the training of directors, not only the announcement, the company should also upload the list of director and their role and function at the same time. Okay, so that they are the summaries on the board of directors and the board committees. Okay, and also regarding effective board practice, I also highlight some key elements for the director induction. Okay, so that sometimes you may need to code the CG code. Okay, regarding director induction, you should list out the director induction, the areas, how to provide the induction program, who is responsible on that, and according to the CG code, all directors should participate in CPD and refresh their knowledge under the listing rule. Okay, and you should have a very good ideas for director duties when you study CSC, Hong Kong Company Law, and also corporate governance. Okay, so that section 465 is very important under the SFO, under the CO. You should also know rule number 3.08 for the listing rule. Okay, so that please list out all the director duties according to the listing rule requirements, and also the respective CG code requirements for the director duties. Okay, and previously there has been one question asked you about board evaluation. Okay, so that you should know some key elements regarding the application of the board evaluation. Okay, including how to conduct internal or external evaluation to the members, to the directors, and also how to use different resources or angle or concept. Okay, and how to make the disclosure in the company and report on the result of the board evaluation. You should also know some composition of the board committee. Okay, including board committees, which all the members must be non-executive directors and at least 3 members. And at least one of them must be IED with the professional qualification in accounting or related financial management expertise. And the majority of the AC must be INED. The chairman of the AC must be the INED, and the former partner has a cooling off period of 2 years, which is restricted from acting as a member of the AC. Okay, and also you should know the RC requirement, the chairman, the composition, and also the disclosure of the RC work at the annual report. Okay, and also nomination committee is also the mandatory requirement for the listed company. The chairman can be the INED or the chairman of the board, and the members should be the majority of the INED. Okay, finally, model code is also important in examination. In particular, what are the backup periods for the company directors? Okay, that is inside information. The director must not deal in any security at any time when he possesses inside information. Okay, according to 8.1 of the model code. Okay, and also the director must not deal in any securities of the issuer by virtue of his position as a director of any other company, where he possesses inside information in that security. That is 8.2 of the model code. And during the time of the publication of the financial result, we understand that there are the 60-day and 30-day bailout periods requirements for the annual result and interim and quarterly result respectively. Okay, so that during the periods of 60 days before the publication date of the annual result, the periods from the end of the relevant periods is the bailout periods. Okay, so that some checklist and compliance issues are expected for the bailout periods. Okay, including send out the notice to all directors, remind them 60-day and 30-day bailout periods requirements, and confirm the security interest in the listed securities at the year-end date, and notify the stock exchange regarding the date of the bailout period, so that the company should submit bailout period notification form to the stock exchange. Okay, and for the security dealing, the director must not deal in the security of the listed company unless there is the confirmation and acknowledgement by the chairman or a designated directors. Then the designated directors must also cannot deal in any securities unless there is the acknowledgement by the chairman. Okay, so that there should be a response to the request for clearance to deal, and also the clearance should not be more than 5 business days. Okay, and finally, at the CG report and this income report is also disclosed below, including whether the company has adopted a code of conduct, whether this director has complied with the model code requirements. In case of any non-compliant, please also disclose the non-compliant details. Okay, now we understand all the focus in section A. I would like to give you some practical example by using the past exam papers. Okay, so that let's take a look on the past exam papers. Okay, so that I have highlighted some key points which would like to draw your attention how to read the question carefully. Okay, of course, reading the subjective answer is very important, but I would like to give you some strategies how to give the answer which can fulfill the examiner requirements. Okay, first of all, before we look at any section B question, you should know the expectation from the examiner and also the mark allocation. Okay, before we look at the scenario, I also give you some highlight, okay, including conventing the board meetings. Okay, and also I also highlight practical consideration just because according to the scenario, there are many issues to convent the board meetings. Look at the mark allocation, 12 mark. This means that you should use around 1.5 to 2 pages to provide the answer on question A. For question B, I highlight the word the director could leave the board or be removed when this could become effective. And also I highlight the word action is required. Okay, and the mark is 13 mark. Okay, this means that you should spend around 20 minutes for that part of the question, and also write around 2 pages for this question. Okay, and the examiner is very, very good. Remind candidate, please do not examine the procedures for convening and holding a board meeting, GM and AGM. Okay, why? I highlight all the keywords here just because they should be the headline or sub-headline in your answer book. And based on the headline and sub-headline, please list out all the rule and regulation and all the corporate secretarial practice to ensure compliance. And apart from that, this is very important to know the story and scenario from the question, including the type of company. The type of company is a listed company in Hong Kong, and the company is incorporated in Hong Kong. Okay, remember, this information is very important just because you are expected to apply the listing rule requirements for that question. Okay, and not only listing rule, please also think about CO because the company is a Hong Kong company. Okay, and even though I do not highlight this scenario, but it is a story. Okay, you should know that the chairman tell you that the journalist has taunted her, Dean, as a director, has accepted briberies from the supplier. Dean declined the allegation, and he informed the chairman he recently acquired a shareholding in the supplier. Then the journalist told her that he intended to publish the story. The chairman wished to convene a very urgent board meeting that is tomorrow afternoon. The issue including that there is insufficient notice. And the chairman does not want the notice agenda or board paper sent to Dean. Chairman is unclear whether Dean should attend the meeting or not, and the chairman is concerned about the quorum and voting because 4 of the 8 directors may not be able to attend. Okay, now look at another story here. This is not the first rumors. She's concerned about how the shareholder could react during the AGM, which we will have in 8 weeks later. Okay, so that after discussion with other directors, the chairman Pan may need to make for Dean to cease being a director of the company. Okay, the question is quite straightforward. Focus on all the scenario and look at the question requirements. Okay, including the board meetings and also the removal of directors. Now look at the Excel report. Okay, this question regard the in conventing the board meetings, including all the practical consideration to the scenario in the question and provide advice on the succession of the directors. Okay, so that part A, student performance is quite good. Okay, on the condition that the student has a very good ideas on the relevant CG code, okay, for the board meeting under Appendix C1 of the listing rule. Okay, in part B, how to remove Dean as a director? Okay, just in case Dean refused to tender the letter of resignation. Okay, of course, removal of director is one of the possible way. However, please also consider the possibility of the retirement by rotation, just because 8 weeks later, the company will hold the AGM. How about Dean should retire and then subject to re-election at the AGM? This point, many students miss this point and fail to evaluate this possibility. Okay, now how to give the answer to the question? That's very important. Okay, first of all, do you remember that the use of headline and subheadline is very important? After you identify all the key issue from the question, so that I highlight the word sufficient notice, you can present all the answer under the headline sufficient notice, just because this is also one of the question requirements, okay, from the scenario. Okay, you need to highlight, according to the CG code, board meeting should be held at least 4 times per year on quarterly interval. According to the CG code, at least 14-day notice should be given of a regular board meetings. For other board meetings, there is no minimum notice requirement, but reasonable notice should be given. All of these are the CG code requirements regarding notice of the board meeting. Then how to define reasonable? Again, no answers. This really depends on case-by-case basis. In view that this story was very urgent, so that the chairman want to give a very short notice. That is, today give the notice and tomorrow hold the board meetings in order to discuss the urgent matter. This seems that the notice period, even though only 1 day, seems to be sufficient. That is the analysis and conclusion regarding sufficient notice. How about the second headline? Notice and agenda and meeting paper to Dean. Again, according to the CG code, all the notice, agenda, and board paper should given to all directors so that they have opportunity to attend the meetings. And according to the CG code, the agenda and the board paper should be sent to all directors in a timely manners. And the CG code also requires that all directors are entitled to access to the board paper and related material. Then the conclusion is that the notice, agenda, and meeting paper must be sent to Dean because of all of these CG code requirements. Then the next headline should be whether Dean should attend the board meetings. According to the CG code, all director has the right to attend all board meetings. Okay, so that under the CG code, Dean should attend the board meeting and answer any inquiry. Okay, the final headline should be quorum and voting at the board meetings. How about the quorum? Okay, this should be true. Okay, for the quorum. And this will not affect the value of the board meeting just because the quorum shall be true, even though 4 directors are absent from the board meetings. And not only the quorum, nowadays the technology is highly advanced, and the CG code also mentioned that the board may use the technology such as video conferencing to convene the board meetings. And also, in case of any conflict of interest issue, which is material, the matter should be dealt with physical board meeting rather than written resolution. Okay, so that the director, even though busy, can attend the board meeting by electronic means and can be counted as a physical quorum. Okay, so that the 4 directors can also use the electronic means to attend the board meeting even though they are outside Hong Kong. Okay, so long as the approval is given by a simple majority, that is more than 50, the resolution can be passed. Since Dean has a material interest in the contract, so that he should declare his interest before the meeting, and he is not allowed to vote and be counted at the quorum. And the director has a duty to avoid any conflict of interest between the company and director interests, so that Dean should provide a very details regarding the execution of the shareholding in the supplier before the starting of the board meeting. Okay, so you can see the answer is very simple and straightforward. Based on the word which has been highlighted and use the respective words as a headline and sub-headline, and then apply all the rule and regulation and provide analysis and give advice to the chairman. Okay, how about part B? Okay, there are several ways to ask Dean to quit from the board. One way is resignation. That is to ask Dean to provide a written resignation letter so that the company can hold a board meeting to approve his resignation. Just in case Dean refused to give resignation letter, again, the CG code also requires that every directors should be subject to retirement by rotation at least one every 3 years. 1/3 of the director who has been longest in services, or a close number to 1/3, must retire at each AGM and then subject to reappointment. Okay, so that Dean could resign and then subject to re-election so that the shareholder can vote again his further appointment so that Dean can be quitted from the board. How about removal of directors? Okay, remember, shareholder approval is required for the removal of directors so that the shareholder should have the general meeting to pass the ordinary resolution. The members should give a backstop notice at least 28 days before the general meetings. Okay, and also 14 clear day notice for general meeting and 21 clear day notice for the AGM. Okay, so that the backstop notice should also be given to Dean, and Dean may make the written representation to the company. Once the ordinary resolution has been passed, then Dean can be removed from the directors. Whenever Dean resign or removed by the board or not subject to reappointment at the general meeting, register of director must be updated. Within 15 days, the company should file the form ND2A regarding the resignation, retirement, or removal. Okay, and please also look at the relation and policy of the company. This will not affect the director right to have any compensation or damages for the loss of office. The announcement should also be published, okay, and provide the reason for his cessation or resignation. Even though Dean has resigned, please also bear in mind that the company should also submit the Form FF004 contact detail form with the stock exchange within 28 days, so long as for the period of 3 years from the day ceasing to be a director. Okay, now let's continue to look at other exam questions, okay, on 223 and June. Again, you learn some technique how to read the question papers, and then let's take a look in this question. Before we look at the story and scenario, look at the question with farmers. Okay, I highlight the keywords appointment of alternate directors and appointments of Henry are valid or not. These two highlighted points can be added as a headline or subheadline in your answer book. And based on these two headlines, okay, remember 14 marks for that question. Okay, this means that you should write around 2 pages to 2.5 pages for this answer. For part B, attendance of the board meeting of non-directors. That is one of the headlines. And the second headline is proposed appointment of corporate directors. That is 11 marks, which you should write around 1.5 pages to 2 pages for 11 questions. Now we have 4 headlines here. What is the story and scenario? First of all, what is the type of company? Private limited company in Hong Kong. The company adopt the model articles. In other words, please do not provide any answer on the listing rule just because this question is related to private company. One of the directors proposed that Megan's or one of the existing director attend as his alternate director just because he is unable to attend in person. The chairman commented that there are 3 issues here from the chairman. Alternate are not permitted. Secondly, his proposed appointment of the alternate director is invalid because the board has not given approval. And the first point is that it is unfair that Leo and his alternate director attend in any future board meeting. This means that this would give them unfair advantages when voting. Okay, again, all of this can be the headline as your answer to give some legal compliance issue, regulatory requirements, as well as evaluation, judgment, and application for all of these practical comments from the chairman. And this was proposed upon Henry as a director. However, Bill find that he was a director that was liquidated last year, so that Henry may not be a qualified person to act as a company director. Okay, and the company has made substantial loss recently, so that the board has been reviewing these strategies, okay, including that receive advice from Antons, which hold 30% of the company, and regularly attend board meetings. Essence also claimed that the size of his shareholding, that is 30%, entitle these shareholders to attend the meetings. And Janet also attend the board meeting to provide the advice on social media experts. Neither of them are directors, and the chairman thinks that their attendance is not a problem. And Leo also suggests that the company should appoint the corporate directors. However, Bill commented that appointment of corporate directors are illegal. Okay, again, in all of these 2 paragraphs, this also provides many information, background, and application regarding the question on directors. Okay, now let's take a look on the examiner report. This question was the most popular question and was the best performed. I should be happy on that. Just in case, when you attend the examination, ask you any about directors and company secretary, you must select this question because these questions are very popular for the student. In particular, appointment of director in part A. For part B, this relates to attendance of non-director at the board meetings. The first part should be no problem just because the question cover appointment of directors. However, some student has a confusion regarding Henry, who was a director which was liquidated last year. Okay, please provide some analysis regarding director qualification. On the contrary, Part B was very disappointing. Okay, in particular, non-directors should attend the board meetings. Okay, and some students overlook the implication. Okay, for these two directors when attending the board meeting, that is shadow director, which are not formally appointed, but they can have the instruction to the directors and employee to act according to their instruction, which are considered as a shadow director under the company orders. Part B student performance was very disappointing. Okay, now let's take a look how to present the answer in order to pass the examination. Okay, first of all, what is the headline? That is when you highlight appointment of Leo as our alternate director. This is a very good headline to illustrate all the legal principle for the alternate directors. Okay, so that who are the alternate director? That is he or she is appointed by the existing director to act on his or her behalf during his absence. The CEO also specified that alternates should be appointed, which should be permitted by the company articles, so that alternate director is deemed to be the agent of the director who appoint the alternate directors. And not only the CEO, the question also mentioned that the company adopt model article. So please also provide some course, okay, under the model article regarding the appointment of alternate director, just because model article specify that the director can appoint the alternate directors. That is, appoint any director or any other person subject to the board approval. So that Leo is able to appoint Megan, who is not the director, or any one of the existing director as his alternate directors. Okay, the model article also provide that for the appointment of alternate directors, this should be effected by serving a notice to the company or in any other manner approved by the board. Okay, so that the appointment of the alternate director is also subject to the board approval requirements. And after obtaining the board approval, the company should also file the Form ND2A with the CR within 15 days, and the appointment should be updated in the Register of Directors. Okay, so that on the condition that the relevant requirement has been complied with, then the appointment of alternate director should be valid. Otherwise, let's say assume there is no board approval, or the company has not filed the Form ND2A with the CR, then this may be correct for the bill to say that Leo proposed appointment of the alternate director is invalid. Then please also provide more explanation on alternate director. That is, alternate director are also fulfilling the definition of director under the CO, and the alternate director are subject to the same fiduciary duties as other directors. Okay, this means that with Megan is appointed, she will not attend the board meeting with Leo is attending. Okay, and with the existing director is appointed as the alternate, then with Leo attend, then the existing director does not add his alternate in the board meeting. Okay, so that Leo voting right at the board meeting, either Leo or his alternate can cast only one vote only on any proposal, even though the director and alternate director attend the board meeting, even though they have two persons, they have one vote only. Okay, and also with the alternate director is no longer required, the appointment can be terminated according to the model articles, and update the register of the director and file the Form ND2A with the CR. Okay, so that Bill comment that the appointment was would give Leo and his alternate director an unfair advantages when voting is totally incorrect. Okay, so you can see the answer provide many rule and regulation, and more importantly, application of the rule and regulation to the case is very important, and then provide the evaluation and analysis. How about another headline which you have highlighted in question 8, appointment of Henry. Okay, then for the appointment of Henry, first of all, what is the director qualification? Okay, first of all, he must attain the age of 18. The person must not act as a director if he is undischarged bankruptcy or under a disqualification order. Then the disqualification order may be made by the court if the person has become a director of an insolvency company, so that he is considered unfit to be a director. Okay, in respect of Henry K, further information is listed just because this can be considered whether he is eligible to be appointed to the board. Just because a business has been liquidated, this does not mean that this was insolvency. What that means? Okay, for example, with the company go through liquidation, there are many ways. This may be member ownership winding up. This may be creditor ownership winding up, or compulsory winding up. This does not mean that every liquidation equal to insolvency. Okay, for example, for member ownership winding up, the financial position of the wind up company must be solvency, just because the board of directors are required to execute the certificate of solvency in order to proceed the member ownership winding up under the CWUO requirements. Even though the company is insolvency, for example, creditor ownership winding up, this does not mean that the director is disqualified, just because the disqualification is based on unfitness. That is, the court could disqualify a person who was a director of an insolvency company just because his conduct was unfit to be the director of the company. Before any appointment, please take a search at the CR, that is the register of the disqualification order in the search and disqualification orders particular search, so that if there is the name of Henry at the register, this means that he is disqualified as a director because of the disqualification orders. But in case Henry has no name at the register, even though his previous directorship company has become liquidated, this does not mean that he is unfitness to act as a company director. Therefore, please ascertain whether the liquidation was solvency or not, and any record find at the CR. If there is no disqualification orders against Henry, this means that Henry can still be appointed as a director. So that when you review all the answer here, this also means that please provide the rule and regulation and provide the analysis and application to the question requirements. Okay, by using this way, not only pass, you can get distinction. Okay, how about question B? Attendance at the board meeting of the non-directors as required by question B requirements. That is the first headline. Who are non-directors? Of course, the major shareholders. Okay, they are not the director of the company, but because of 30% shareholding, the major shareholder can also attend the board meeting. But please only limit their advice in their professional only. Otherwise, they may be deemed as a shadow directors. Okay, so that director must exercise care when considering attendee at the board meetings. In particular, that when the non-director frequently attend the board meetings, there may be a risk that the non-director is considered a shadow director. That is, the shadow director who is not appointed as a director, who manage or direct the affair of the company or the action of the directors. Okay, section 2 also defines the director as any person occupy the position of the director, regardless of his or her job title. Okay, for example, any person has the function as a director is a director. Okay, for example, has the power to convene and conduct a board meeting, or to approve the allotment of shares, or to approve the execution or disposal of assets. Okay, so that for all purpose, any person who occupies this position to approve the execution and disposal of major assets, then the senior management may be regarded as our directors. In this case, the shareholders who hold 30%, and also Janet is a professional advisor, frequently attend the board meetings. Now, the point of concern is that shadow directors are deemed directors for all purposes. And the common law principle, that is the fiduciary duty and duty of care and skill. And also, the CWO, governing director, also apply to shadow directors. Okay, so that since the business has made substantial losses, should the company become insolvency, so that the liquidator or receiver may take the action of the Aston and Janet, who are the shadow directors. If they are considered to be shadow directors, they will be reviewed that whether they have any wrongdoing has been committed. Okay, so that the board should keep bear in mind regarding the statutory duty of running the company. The board should ensure that all the professional advisors, in this case, corporate director and Janet, should restrict their advice only to their area of expertise. If they present the board meeting on a regular basis, formal appointments should be prepared, and they should be subject to the formal appointments. Okay, so that professional advisor with the advisors are able to provide a wide-ranging advice that the director regular act upon, they are likely to be considered as a shadow director. Okay, so that shareholders do not have the right to attend the board meeting. Remember, they are non-directors. Okay, so that the shareholder, even though attend the meeting, please do not have any decision on the board meeting or make any instruction to the directors and this company. The board of the company should make a decision how to deal with Anton. For example, if this should stop his attendance, then invite it to be formally appointed by the board as a director or appoint a representative as an advisor. Okay, finally, how about the final headline, appointment of corporate directors? Okay, what is the CEO requirement on corporate directors? Okay, that is a body corporates and can act as a director of a public company if the company is not a member of the listed group of company. And private company must have at least one director who is a natural person. Since Atkins is a corporate director, board approval is required. Form ND2A should be filed with a CR within 15 days, and the instant particular must also be entered at the register of directors. All of this is the CO requirements. How about the evaluation and comments? Everything is totally legal according to the CO. So that the bill's comment that corporate director are legal is not correct. Okay, so please take a look all the headline and based on the scenario to provide answer to the question. Question on 2022 November. Before we look at the scenario and the story, again, please try to understand the focus from the examiners on that question. I also highlight some keywords which can be used as a headline and sub-headline when you present the answer to the question. Okay, first of all, appointment of sales. Okay, and another appointment is external service providers as the new company secretary. Okay, and another headline is the possibility of the stock exchange grant a waiver from strict compliance with the qualification experience for a new company secretary. Okay, interestingly, the mark carry 17 mark. This also means that you should write around at least 3 pages for this 17-mark question. Okay, you can see the proportion of question A is very large for that question, so that you must provide a very comprehensive answer on that part in order to obtain all of these 17 marks. Okay, for part B, I highlight the word formalities. Okay, including appointment a new company secretary to fill the vacancy because of fan debt. Okay, that is another headline. Okay, now look at the scenario and the story for that question. What is the type of company? Okay, the company is a Hong Kong company, and these shares are listed on the stock exchange. That is a listed company. And Fan is a company secretary. Unfortunately, the CEO told that Fan died yesterday. He wants to know the formality to appoint a new company secretary, so that he has several concerns on the following point. Again, they can be viewed as a headline, okay, in order to provide explanation on the appointment of the new company secretary. First of all, Sarah, who is a secretary, worked with the company for 10 years. Sarah could be a good repayment for Fan and consider Sarah as a new company secretary for that listed company. There is another option. Engage the external service provider as a new company secretary. Okay, that is another option. He wondered whether the company could apply to the stock exchange for a waiver from strict compliance with the required qualification and experience for a company secretary. Okay, interestingly, apart from the type of company, please also look at the scope of operation. That is, principal business activity are in Hong Kong. Okay, this may affect your judgment whether the stock exchange may grant the waiver on the qualification of a new company secretary. Okay, now let's take a look on the Excel report. Okay, this focus on company secretary and the formality for the appointment of the new company secretary for a listed company. Again, this type of question was very common and popular, and student performance was quite good. Okay, so that's the reason why I should be happy and with you are one of the candidates. This type of question you must select. Okay, more of the students understand the academic and professional qualification for the company secretary. However, some students overlook, okay, with the company engaged, okay, the external service provider, that should be the non-compliant of the CG code C.6.1. Okay, just because CG code requires that the company secretary should be the full-time employee of the company. Okay, and unfortunately, some students did not read the question carefully, including that there are many students provide a answer, role of the company secretary. Okay, please look that there was no question requirements ask you about the role of the company secretary, so that you must understand the focus and requirement from the examiner, even though you have a very good preparation on the role and function of the company secretary in a listed company. Okay, and unfortunately, there is no or little alignment to the specific requirements of the question in relation to the scenario. Okay, all of these are the common expectations from the examiner. You must link up all the theory with the practical situation and scenario. Then, how to make use of the headline to present the answer? Okay, first of all, appointment of Sarah. What is the listing rule requirement on that? Okay, first of all, you must list out all the listing rule requirement on the qualification of the company secretary. First of all, academic or professional qualification, which should be either the member of the HKCGI, a solicitor or barristers, and a CPA. How about relevant experience? First of all, length of employment with the listed company, familiarity with the listing rule and other law and regulation, for example, SFO, CO, CWUO, and takeover OCO, that are exactly the syllabus of the CSC. Okay, relevant training. okay, which the minimum requirement should not be less than 15 hours. And also professional qualification in other jurisdiction. Okay, with Sarah does not possess any professional qualification and relevant experience because according to the question, Sarah is only a personal secretary only, even though she worked for the company for 10 years. This means that she is not a member of the HKCGI, solicitor, barrister, or CPA, so that she is not capable of discharge the function of a company secretary. Okay, how about another headline? Apart from Sarah, that is appointment of external service providers. Again, looking at the CG code, C.6.1, the company secretary should be the full-time employee of the listed company, who has a day-to-day knowledge of the listed company affairs. With the listed company engage the external service providers, this should disclose the identity of a person with sufficient similarities. Okay, for example, the chief legal counsel or CFO, who the external providers can contact. Therefore, the appointment of the external service providers will deviate the cook provision because the partner of the professional firm is not the employee of the company. Then the director should consider acceptable reason why the company has chosen to deviate from the cook provision in the CG code. How about another headline? Possibility of the exchange to grant a waiver. Okay, of course, this is not a listing rule requirement. However, according to the guardian letter from the stock exchange, the stock exchange may grant the waiver to the listed company to comply with the qualification of the company secretary. Okay, and the period should normally be 3 years. Okay, on the condition that the new company secretary must be assisted by a person who has the qualification or experience, that is the joint company secretary. And according to the 2022 Stock Exchange Guideline, under what circumstances the stock exchange may grant the waiver to comply with the CompSec qualification. Okay, there are 3 factors considered by the stock exchange. First of all, the location of the principal business activities, whether outside Hong Kong, whether the company is able to demonstrate the need to appoint a person who does not have the qualification or experience, and the reason why the director consider the individual to be suitable to act as the company secretary. Okay, as the company is a Hong Kong company, and more importantly, this principal business are in Hong Kong. This means that the stock exchange is unlikely to grant the waiver to the company, so that the Hong Kong company must appoint a qualified person who has the acceptable qualification or relevant experience, for example, HKCGI member, okay, instead of a personal secretary. Okay, how about the second headline? Appointment of the company secretary to fill in the vacancy. Okay, I believe that this part of question is very straightforward on the condition that you have a very good knowledge, okay, on reading the company announcement, okay, on the training of company secretary. Okay, first of all, according to CG Code C.6.2, the company should hold a physical meetings to discuss the appointment of the company secretary to fill the vacancy because of the death of the former secretary, rather than passing a written resolution. Okay, so that we need to highlight the CG code on that. Okay, for board approval, this is a more good CG practice. That is by using a physical meeting to approve the appointment of the new company secretary or new repayment. And also, the new company secretary should also provide his or her written consent to act as a company secretary. And because the company is a Hong Kong company, so that after appointment, the company should file the Form ND2A with the CR within 15 days. And more importantly, public the announcement for the appointment of the new company secretary and the succession of the former company secretary because of his death, include the effective date, qualification of the company secretary on the website of the company and the stock exchange. Since company secretary is also a officer of the company should sign a service contract with the new company secretary. And similar to directors, after the appointment, within 28 as soon as possible, the company should provide a form FF004, that is contact detail form, for contact detail of a new company secretary. And more importantly, since company secretary is an officer of the company, the company D&O liability insurance should also cover the appointment of the new company secretary, because company secretary is performing the statutory duty. And finally, update the company register of secretary. And also at the annual and interim report, please also disclose the train of company secretary. Okay, so that you can see part B is very straightforward, focus on the appointment of the new company secretary for a listed company. So this question is very straightforward. You should highlight all the keywords from the question requirement and understand the exam requirements. After you highlight all the keywords, please also make sure all of them as a headline and sub-headline. And based on your knowledge and understanding of the listing rule, list out all the rules and regulations. And finally, provide the application and conclusion and evaluation regarding appointment of seller, appointment of external service provider, and whether the stock exchange is likely to grant a waiver. Okay, now look at another question on 2022 November. Okay, before we look at the scenario and story, please look at the question requirements. I highlight 3 persons here because they are the company directors. Whether the company can provide loan. Okay, before we look at the story, we understand that it's a loan provided to 3 directors, Betty, Patrick, and Dana. Interestingly, 70 mark. Okay, so everyone can be the headline, and more importantly, you are expected to write around at least 3 pages to obtain 17 mark. This also implies that question A requires you to provide a very detailed and comprehensive answer. Okay, another question asks about whether a company can acquire the small warehouse from AA. That is the headline. And what action should the director take? Okay, and this is quite nice that the examiner has a gentle reminders, including that this question does not examine the procedure for convening a board meeting or shareholder meeting. And that's very important. The NAV is $1 million. Core of share capital is also $1 billion. Okay, that is for exam purpose only. It is not reflecting the real life. Okay, that's very interesting scenario. But please bear in mind that this is only the exam question only. This is not the real case. Okay, just because this may not make sense. NAV is equal to core of share capital. But anyway, let's take a look on the story and scenario. What is the type of company? Okay, that is Hong Kong private company named by shares. And company adopt model article. This also means that please do not mention any listing rule just because the company is a private limited company in Hong Kong. The company NAV $1 million. Core up capital is $1 billion. Okay, now the foreign director has asked the company to provide loan. Okay, this question is typically loan to directors. Now look at B director here, Baptiste, asked for the loan of $100,000. The purpose is to pay for her son to study abroad. Patrick and other directors asked for the loan of $40,000. Purpose is to buy a car for personal use. Dina and other directors is moving home and asked for the loan of $90,000 to pay the deposit on her residential premises. Dina also travel overseas on business next month, and the company were to advance her a fund of $60,000 so that she can book the flight and arrange as very short notice. The loan to the director is very urgent and by the credit would. However, we don't know is the director loan are permitted under the CO or not. Another scenario is that the company is considering to acquire a small warehouse from AA as a consideration of $1 million. Helen aware that the director of the company, that is ABM, is also a director and shareholder of AA. This means that the director has an interest on AA who dispose the small warehouse to the company. Is there any conflict of interest? Or even though that is conflict of interest, how to obtain the board approval in order to acquire the small warehouse from AA, which the director has the material interest on that company? Okay, so this very clear cut. Part A asks you about director loan. Part B asks you about declaration of interest in case of any conflict of interest between the director and the company. Okay, this question asks you about loan to director. This really depends on the understanding of the CEO regarding the restriction, okay, for the loan of directors. Okay, so that if they do not know loan to director under the CEO, their performance should be very poor. On the contrary, the CEO has a requirements. Under what circumstance the company can provide loan to the directors. The second part will deal with the conflict of interest in a public company. Okay, and interestingly, some students did not read the question carefully and provide the listing rule for the listed company. I don't know why, just because the company is a Hong Kong private company, not model article. But why students call the listing rule, as I mentioned before? Okay, please do not repeat all of this mistake. Okay, how to give the answer regarding loan to directors? Okay, first of all, what is the CEO requirement for loan to directors? Okay, according to the CEO, loan to director are prohibited. The company must not make a loan, a guarantee, or any security directly or indirectly to a director of the company or this holding company, or to the company in which one or more of these directors has a controlling interest. Okay, this applies to all companies. However, there are two types of company that are exempted. That is licensed bank and licensed deposit taking company. Just because these two types of company, their ordinary and usual course of business is the provision of financial assistance. And the law also has exemption. Okay, including that the loan of value not more than 5% of NAV or 5% of a core-up share capital. A loan for expenditure on company business. And if the company provide the director a loan for purchase his or her residential home. Okay, so that not only the restriction, this also lists out the CEO exemption, which allow the company grant the loan or provide guarantee to the director of the company. First of all, one of the headline is Betty. Okay, what is the loan amount? $100,000. Okay, so that after we get a very simple calculation, what is the ratio for this director loan? That is 10%. As the value is more than 5%, both of the NAV and core up capital, the loan is prohibited. Therefore, the company may not make a loan of 100,000 to Betty unless higher shareholder approval is obtained. Where shareholder approval is required, the company must send these shareholders a memo or any board papers regarding the nature of the transaction, amount and purpose of the loan, and the extent of the company liabilities. How about Patrick? The loan amount is $40,000. Okay, when we calculate the ratio here, that is 4%. At the value of the loan does not more than 5% of the NAV and 5% of the core up capital, the exemption applies so that the company may make a loan of $40,000 to Patrick. So that everything depends on the size of the loan. Even though the ratio is more than 5%, is there any prior shareholder approval? Otherwise, director loan is restricted. How about Dinas? Okay, loan of $90,000. Okay, more importantly, The purpose is to deposit on her residential new premises. Okay, so that you need to list out section 509 of the CO. What are the exceptions for the home loan? Okay, so that you need to list out the following section, okay, regarding the exception for a home loan. Okay, including that the loan is to enable the director to purchase or improve his or her only or main residential premises. The total amount of the loan does not more than 10% of the NAV or call-up capital. The granting of the loan is on term not more favorable than other granted on transaction entered in by the company in this ordinary and usual course of business. For example, the director pays market interest rate on the loan. The company should appoint the professionally qualified valuation surveyor, okay, to produce a valuation report on the residential premises purchased by the directors within the preceding 3 months of the purchase. And finally, the purchase of the residential premises is secured by a legal mortgage. Okay, so that the company has the priority over other classes of creditors in case the director fails to repay the loan. Okay, so that please memorize all the exceptions to the home loan. After we calculate the ratio, that is 9%. Since the value of the loan does not more than 10% of the NAV or call-up share capital, and provided that all other conditions has been satisfied, the exemption under Section 509 apply, so that the company may grant the loan of $90,000 to Dina for the purchase of his, her, or her residential premises. How about the final loan? Okay, because the company also provide advance a fund of $60,000 to Dina. Okay, for business purpose. Please take a look on the exception. Exception also include for meeting company business expenditures. Apply with the purpose to provide a fund to the director is to enable the directors to perform his or her duties as the director of the company. And also, according to the model articles, the company must pay any traveling, accommodation, and any other expenses properly incurred by the directors in connection with the exercise of their power and the discharge of their responsibility. Okay, so that the company may advance a fund of $60,000 to Dina. Okay, so that based on all of these 4 headlines, please list out all the CO requirements on loan to directors and provide more analysis on that. So that's the reason why you must memorize loan to directors. What are the restrictions and the exemption? And also, what are the exemptions for a home loan to the directors? Okay, regarding part B, okay, that is highlight execution of the small warehouse from AA and what action is required. Okay, first of all, according to the AA, just because AA constitute a conflict of interest, then the company has a duty to avoid any direct conflict of interest between the company and these directors. And model article specify that with the director is interest in a transaction with the company that is significant in relation to the business. And if the director interest is material, then the director must declare the nature and extent of his interest to other directors. Model article also specifies that the director must not vote in the transaction, nor can the director be counted as the part of the column. And before the company enter into the transaction, the director must make a declaration of interest in the transaction. And the law also required that the director must declare any interest in transaction, okay, at a director meeting, or notice in writing and send to all director, or make by a general notice by the directors. Okay, Helen is aware that ABM is a director and shareholder of AA, which could not exempt IBM from the requirement to make a declaration of interest to the directors. Okay, so that the execution of property require the director approval. The company could acquire the small warehouse based on several conditions. First of all, there is a board approval at the board meeting or by written resolution. ABM has declared the nature and extent of his interest to other director before the company enter into any agreement with AA. ABM sustained from voting and is not counted as a part of the quorum of the board meeting. ABM declaration of interest is properly discussed and recorded in the minutes or in written resolution. Okay, so that based on all of the procedures, the company is able to acquire the small warehouse from AA and also avoid the conflict of interest between the director interest and the company. Okay, so the question is very straightforward. One of the conditions is that you must familiar with the CEO and the model code requirement regarding loan to director and declaration of interest. And based on the question requirement, provide all the headline and make use of the scenario and the story. Provide all the rule and regulation and application to the case. Okay, then you can see using of headline is very important to let you not to misunderstand the question requirements. Okay, now let's continue to look at another past exam paper on 20226. Okay, this seems that this question is very straightforward, and please highlight the word formalities. Appointment a director to fill the vacancy. Okay, that is the major focus from the examiner. Okay, another question also very straightforward. Formality for changing the company name. Okay, everything can be highlighted and can be used as a headline for your answers. And the mark allocation is 15 mark and 10 mark respectively. This means that please write at least 2 pages. Okay, or 2 from 5 pages for 15 mark and at least 2 pages for 10 mark question. What is the type of company for that question? Okay, the company again incorporated in Hong Kong and the share are listed on the Hong Kong Stock Exchange. That is the listed company. Okay, now there are 2 points here. The death of Patrick as a director, who died yesterday. Now the board is considering to fill his position on the board ahead of the next AGM. Okay, which is scheduled to be held on 10 months later. Okay, this means that now we need to appoint the directors. Can we wait for AGM? Or can we appoint the director now by the board? Okay, before the AGM. Okay, another question asks you about the change of company name, okay, to another company as soon as possible. Okay, so that this question is very straightforward. Okay, and let's take a look on the examiner comment. Okay, this question asks you about appointment of directors in order to fill a vacancy arising from the director death, and also the formality required for changing the name of the listed company. Again, this question was very happy for me just because the question was very common, popular, and best performed in section B. However, some students were unable to obtain a higher score, okay, because they did not describe the appointment procedures because the company is a Hong Kong listed company. Okay, and the question also asks you about appointment of director, but I don't know why. Some candidates focus on that of the director, which is totally unrelated. Okay, for that question requirement, appointment a director to fill the vacancy. This also shows that candidate did not read the question carefully. Okay, on the contrary, with the student read the question carefully, they have a very good knowledge for the listing rule for regarding appointment of director and the change of company name. They are able to score a very high mark. Okay, honestly speaking, this question was very simple and straightforward, but I don't know why some students misread the question. Okay, or providing the answer which is not related to appointment of directors. Okay, now let's take a look on how to use the headline to illustrate the answer. Appointing a director. Okay, first of all, we need to list out all the formality for the listed company. How to appoint a director to fill a vacancy. Okay, everything, including private company, check the article of association regarding appointment of directors. Whether the director can be appointed by the board. Okay, if not, the new director should be appointed by a shareholder resolution at the EGM or AGM. Okay, The notice of the general meeting should contain the detail of the proposed directors. Okay, usually the A articles grant the board of authorities to appoint any new directors. Okay, before we have the board approval for the listed company, there should have a meeting of the nomination committee, which help to select and recommend suitable candidate for the board to consider appointed. The company should have the nomination policy and the board diversity policy, and also the according to the statutory requirements. Patrick was one of the ED who was ordinary resident in Hong Kong. Okay, and nomination committee should ensure that the number of ED who are ordinary resident in Hong Kong does not less than 2. Okay, and also look at the disqualification of directors. The company should conduct a company search, okay, at the official receiver office and the company registry to ensure that there is no bankruptcy order or disqualification orders. The company should hold a remuneration committee meeting to approve the remuneration package. And the CEO, without the prior shareholder approval, the company must not enter the service contract, which the guaranteed term of employment is more than 3 years. According to the listing rule, shareholder approval at the general meeting must be appointed with the company grant this director a service contract which is more than 3 years terms and expressly require the company to give a termination notice of more than 1 year or to pay compensation equivalent to more than 1 year remuneration. With Patrick is the independent non-executive directors, then please make sure that at least 3 INED, which represent at least 1/3 of the board. Okay, so that the proposed appoint new director should fulfill independency requirements. And with Patrick was only the IED who possessed the professional qualification, accounting or financial management background, then the board should select an approval candidate. Okay, and backed by that, at least one of the IED must have the accounting or financial qualification and expertise. And with Patrick was also a member of the executive committee, then the board should also select the appropriate candidates, okay, to take into consideration the ability to fill the vacancy of those board committees. And later on, board approval, okay, to approve the appointment of new directors, service contract, and receive any declaration of interest. Then the company publish the announcement at the company website and the stock exchange website, including the following information. At the same time, upload the update list of director and their role and function at the website. File the Form ND2A within 15 days after the appointment. As I mentioned before, Form B has been abolished so that instead of using Form B, please bear in mind that before the new appointments, the newly appointed director should receive a legal opinion from the firm of solicitor regarding the listing rule requirements and the director duty. So please update Form B has been abolished. Okay, and on the contrary, the newly appointed director should obtain a legal advice. Submit the director contact list Form FF004 to update the up-to-date contact information with the stock exchange. If the newly appointed director has security interest in the company, then within 3 business days, file the Form VA, that is a notice of director interest, to the stock exchange under Part XV of the SFO. The company should publish the update the register of directors, update the information of the company website, provide induction training, fulfill the composition and diversity, and disclose the chain of director in the annual report and interim report. Okay, so they are the comprehensive procedures regarding appointment of director to fill in the vacancy. Okay, in the second part, how about the change of company name? Okay, again, read the question carefully. Formality for the listed company to change the company name. First of all, conduct the company name search to make sure that the company name is not same as or similar name to the existing record at the CR. Otherwise, CR will reject the change of name application. Okay, since the AGM will be held 10 months later, shareholder approval is required for the change of company name, so that the company must get the approval of the board and convene the extraordinary general meeting EGM to approve the change of company name. Then the company should publish the announcement regarding that the director agree the proposed change of the company name at the board meetings on the company website and stock exchange website, and then publish the notice of the EGM and circular, okay, at the stock exchange website, and 14-day notice period is required. Then at the EGM, pass the backstop resolution, which require at least 75% approval of these voting shareholders. After the backstop resolution is passed, publish the poll vote result announcement of the EGM at the website. Since the company is a Hong Kong company, file the Form NNC, Notice of Change of Company Name, within 15 days with the company registry after passing the backstop resolution. Then the CR will issue the certificate of change of name. Since the company share is listed on the stock market, not only the change of company name, the short stock name in English and Chinese should also be amended, so that the company should also submit Form CFO 9V to the stock exchange for the adoption of new stock short name. And then order a new company seal, new company chart, update the share registrar, reprint the new share certificate, and also inform all the regulatory body, IRD, bank, customer, supplier, and also update the business registration certificate. Okay, so that this question is really, really straightforward. Okay, on the condition that you know all the listing rule requirements regarding the procedure for appointment of director and also change of the company name. Okay, so that with the question carefully is very important. And I also see that the marking scheme provide a very good answers for you to study the appointment and change of director for the listed company and change of company name for the listed company. Okay, now look at the final question, okay, in this material. Okay, that is the past exam paper on 2020 November. Okay, similar to the previous practice, this is that the scenario and story is very long and comprehensive, but please bear in mind before we look at the case and scenario, let's take a look on the question requirement first. Okay, I highlight the word appointment of Deborah and Wayne. Okay, regarding the does the tell compliance and non-compliance and recommend the remedy action where there is non-compliance. Okay, again, we don't know the story and background, but at least you should know the statutory requirements. What are the remedy action in case of non-compliance for these two appointments? Okay, and also advise additional course of action. Okay, to effect a change of director with the company was a listed company. Okay, that is another scenario here. If the company is a listed company, what is the additional course of action required for the change of directors? Please look at mark is 16 mark. This means that you should write around 2.5 to 3 pages for 16 mark question. Okay, and another question. Okay, I highlight the company has not held AGM since 2014. Discuss whether the company breached the company orders and how to deal with the reappointment of the auditor if there is no AGM. Okay, so the mark is 9 mark. Please write around 2 pages. Okay, with it is lawful for the company not to hold AGM, and in case there is no AGM, how should we appoint the external auditor? Now let's take a look on the story and scenario. First of all, what is the type of company? The company is a private company in Hong Kong. Okay, financial year is 30 June. Okay, and interestingly, when you see question A2, we assume that with the company was a listed company. So that what is the additional course of action for the change of directors? But in reality, the company is a private company in Hong Kong. Deborah was appointed as a director in 2020 January. Due to error, the appointment Form ND2A has not been filed with the CR. Okay, Carrie is very concerned. Deborah has approved several transactions in the last few months. Okay, this is non-compliant of the CO just because the company has not filed the Form ND2A with the CR. Then what is your advice and remedy action on that? Okay, according to the CR record, Wei was appointed as a director in May. However, Wei told her that he did not remember agree to his appointment, so that he would like to dispute these validities. And Carrie cannot find any document in the company file about the appointment. Again, it is non-compliant with the CO. Okay, for the appointment of new directors. For the first case, Form ND2A has not been filed. For the case for another scenario, Carrie cannot find any board mini record for board approval. Okay, think about the non-compliant issue and what are the remedy action. Okay, another issue here, the company has not hold the AGM since 2014 and only member written resolution has been passed. Carrie think that some of the written resolutions are invalid because not all shareholders approve them. And some of the resolution has not been signed. It seems that this is a very practical question. We may be worried about that the resolution has not been fully signed by the shareholders. Okay, or some shareholder has not signed the minute. Okay, there is no written resolution to approve the appointment of external auditors. Okay, so that is no AGM. So you think that external auditor has not been validly appointed. Okay, and she also find that one day, one shareholder who hold 4%, that is minority shareholders, object auditor reappointments. Okay, so there are many story and scenario for that question. No need to worry on that. Based on every headline outlined, then based on the scenario and story from the question, please provide the advice and what is the rule and regulation on that. Okay, now let's take a look on the Excel report. Okay, this question covers the appointment of director and reappointment of auditor. Unfortunately, students misread the question. They did not understand the question requirements, and some of the answers were totally unrelated to Deborah and Wei's situation because they overlooked the background and story of the question. The question clearly stated that Wei could like to dispute the validity of his appointment. However, some students only answer the procedure for how the director to resign, which is totally unrelated to the question requirements. And also, some students only provide a general answer regarding the CO or the listing rule. There is no reference, no relationship with the case. Please do not repeat all of this mistake. And I feel that this question is a good benchmark for you to learn to avoid the previous student mistake. Regarding part B, the third element is regarding the holding of the AGM requirements. Okay, this seems that student answer is quite good. Okay, regarding the exemption of the AGM. However, regarding the reappointment of the auditors, the answer was very weak. Okay, so that please read the question carefully and link up the relationship between the question requirements and the case scenario. Okay, now let's take a look based on different headlines, how to present the answer. Okay, for the first case, Carrie. Any secretarial compliance and non-compliant. In case of non-compliant, what is the proper actions? Okay, first of all, the company can appoint directors by passing the owning resolution by member or the board approval. After the approval, either by shareholder or directors, within 15 days, file the Form ND2A. And the form, every director newly appointed must sign the consent to act as our directors. Okay, and the Form ND2A, okay, should also disclose, state the newly appointed director name and also personal particular. Again, please update because Hong Kong has implemented the new inspection regime. Okay, so that please repeat correspondent address and parcel ID number or parcel passport number only. Okay, so that this is a public record for Form ND2A. Okay, so that the company has the tell duty to notify the company of his or her personal particular under the CO. And every company must keep a register of directors. Okay, a member of the company and the public can make inspection on the register of director. Okay, now let's take a look on appointment of Deborah. There is no Form ND2A filed with the company registry. However, there has been several transactions approved by Deborah in the last few months. Okay, therefore, please consider whether the appointment is defective so that the contract and transaction are also invalid. Okay, first of all, looking at the CO, this provided that the member may ratify prior act of directors for the acts of negligence, default, or breach of duty or trust. Therefore, the member resolution shall ratify the act of Deborah and any other directors. Then the resolution should be passed in a general meeting or by a written resolution to ratify the appointment of Deborah. Okay, so that Deborah should sign the consent to act in Form ND2A and then file the Form ND2A with the CR. The company should also update the register of directors. All of these are the remedy actions for the non-compliance of the CO. How about another directors? Okay, we cannot allocate any board minutes or board approval for his appointment. He wants to dispute his appointment. Okay, proper appointment is required for the board approval or shareholder approval, as well as the newly appointment of director consents. And also, his particulars should be updated in the register of directors. However, even though Kerry cannot find any document in the file, please bear in mind that Form ND2A is a public record. Kerry can conduct a company's form of ND2A. With there is a Form ND2A and directors. So long as CR records show that he has accepted the appointment of the director, he has no ground to dispute the appointment. Okay, therefore, the company ordinance also provided that the company must keep these minutes of meeting or written resolution available for inspection at the register office. Another part two, assuming that, how about if the company is a listed company? Okay, I do not go deep on that just because according to the previous answer analysis, first of all, nomination committee to evaluate the skill and characteristic of the new directors, and also hold the evaluation committee to approve the director evaluation, have the board meeting to approve the new appointment, public the announcement at the website, public the update list of director and their role and function on the website, provide the up-to-date contact list that is Form FF005. Okay, that is contact form to the stock exchange. Again, Form B have been abolished so that the newly appointed director should obtain a legal advice, okay, from a firm of solicitor regarding the director duty and comply the listing rule. The company should provide comprehensive, formal, and tailored induction. Okay, so long as there are sufficient formality, it is unlikely that the director can dispute the validity of the appointment. Okay, so you can see the answer is very comprehensive. You should, based on the headline, identify from the question requirements, and then provide all the CO and listing rule requirements, and provide the analysis and evaluation on the question. Okay, how about part B? The company has not hold AGM where the company breached the CO requirements. This means that please consider when the company need not hold the AGM. Okay, so that even though there is no AGM, that is still lawful. Okay, the company is not required to hold the AGM. First of all, with everything that is required to be done at the AGM is done by a written resolution. And a copy of the document required to be laid or produced at the AGM are produced to every member of the company. Okay, so that the CEO allow the company to dispense with the holding of the AGM by a written resolution. Okay, and a company is required to deliver a copy of the resolution to the CR for registration within 15 days. Okay, that should be the reason why the company has not hold the AGM. If the company has passed the resolution and provide a copy of the resolution to the CR for filing, even though the company has not hold the AGM, the company has not breached the CO. Okay, so please consider the exemption of not holding the AGM under CO. How about the reappointment of external auditor if there is no AGM? Okay, please highlight that only dormant company are exempted from the requirement to appoint the auditors. Okay, so that every company should at its AGM appoint the auditor to hold the office until the next AGM. Okay, and the auditor, as at the end of the appointment period, is deemed to be appointed for the next financial year according to the CO. And any member may request the company to convene the AGM. Okay, to give notice no later than 3 months before the end of that period to hold the AGM. Then the company may revoke the resolution dispensing with the AGM by passing the ordinary resolution. Then the company should hold this AGM within 5 months after the end of this accounting reference period. Okay, because the financial year end is June 30, so that the deadline to hold the AGM should be on or before March 31 of the next year. However, we understand that there is 1.4% shareholder make the objection, okay, regarding the reappointment of the external auditor. What is the legal protection for the small shareholders? According to the CEO, the shareholder hold more than 2.5% has the right to require the company to give the notice to the shareholders to pass the resolution, and the company has a duty to circulate the resolution for the AGM. Therefore, 4% shareholders may make objection to the auditor reappointment at the AGM. Okay, so that the resolution to reappoint the external auditor will require a simple majority vote, that is more than 50% of the voting right at the AGM. Since the small shareholder hold 4% of the voting shares, the small shareholder does not have sufficient voting right to vote against the resolution to reappoint the auditors. Okay, honestly speaking, there's a little bit difficulty for that question because there are many compliance issues for the question. No need to worry about that, just because you are able to understand the question requirement by using the respective headline in the answer box. And based on the story and scenario, you can apply them, highlight all the points here, and then apply them to the question. You need to list out all the CO and listing rule requirements, and then provide the answers on application, provide recommendation regarding the lawfulness of the event and the transaction, and then make the conclusion and analysis according to the marking scheme requirement. So that's the reason why, apart from studying the study pad, reading the past exam paper, and also the subject answer is very important. And we can also learn some previous student mistake, okay, and avoid all the previous candidate mistake. Okay, now we finish all the Section A past exam papers, and I would like to give you the conclusion on today, the first card recording lectures. Okay, as I mentioned before, in order to pass the examination, there are some skills required for the examination. Apart from the study pad and also the past exam papers, we see that more of the past exam paper, their questions are very practical. Practical means you should assume yourself, you are the professional company secretary and governance professional. Okay, so that there are many problems for the company, the chairmen, and the directors. There may be a chance that the company cannot comply with the CO or the listing rule requirements, so that you can view yourself as a doctor. How to take all the remedial actions to ensure compliance. Okay, there are many corporate secretarial procedures, including how to obtain board approval, shareholder approval, how to fulfill the statutory return requirements, how to pass the resolution at the meetings. What is the form and document required to fulfill the regulatory body requirements so that you can provide all the judgment, provide example from the case study, okay, and then make all the application, link up the theory together with the application. So that's the reason why when you take a look on all the past exam answers, it's really a very good example which can provide a very key adjustments and deep analysis, okay, regarding the theory and also the practice. Okay, and I can say that even though all of the questions are the exam question, in reality, this may be happens to some company, okay, because non-compliant is very common in Hong Kong private company and listed company when you read the website of the CR and the stock exchange. So that as a company secretary, ensuring compliance is the basic duty, and we are able to provide our corporate secretarialship and compliance, okay, in order to ensure compliance. All of these are the learning outcome requirements, okay, for today's class. Okay, now we can finish today recording lectures and see you in the next recording lectures.